All right, let me get all set up. So give me just a second, and I'm going to see if I can share this video on. All right, I'm hearing too much feedback. All right, turn my volume down. So give me just one quick sec. Let me see if I can share this really fast in the group. All right. They don't make this easy. Okay, so I had to do this video. I'm having to do it on my page, and then I have to share it in the group. So just give me one quick second while I do that. All right, we are ready to roll. Okay, so I'm going to put my phone down. I can't quite see my camera, but I'm hoping you guys can see me. I'm going to keep my phone up. So if you can't see me, then write a comment, and hopefully I'll be able to actually see it on here. All right. So what I wanted to do with you guys is I wanted to walk through a basic contract. Thanks so much for the contracts that I received from several of you all, but a lot of them were a little bit long, so I actually took one that I had buried somewhere on my computer, and this is pretty raw. I haven't done anything to it. It's just the raw template. I don't know if you can see it here on your screen. Hopefully it's not blocked or obstructed or anything. But what this is a confidentiality and non-solicitation agreement. And like I said, it's very vanilla, it's very basic. However, I'm going to walk through it and just kind of let you guys know kind of some of the things that I'm seeing as I'm seeing it. Oh, and by the way, I know this is probably like the worst time to have a Facebook Live, so I'm not so much worried about that. It's going to go hopefully in the archives, and then you guys will have it as a resource to watch it later. So I know I'm really bad about these Facebook Lives. I swear they really, really, really don't like me. Alrighty, so I'm going to go ahead and jump in. And like I said, if you guys have questions, I'll have my phone by me. So I'll hopefully be able to see it from my phone, and I'll be able to answer the questions. So I'm going to go through, read it, and just walk through it as and talk out loud as I'm thinking. So confidentiality and non-solicitation agreement. Agreement made between blank and a blank entity of company, herein called company, and blank, herein called the employee. Okay, so employee. So that's the first thing that's wrong with this is there needs to be employee right there. And I'm going to highlight that. And by the way, after I'm done marking this up, I will go ahead and post a copy of it in the group so you can have it to take a look at. So let me go into review, and I'm going to put a comment in there. Needs to specify employee, sorry. Okay. All right, whereas employee is employed as an agent or employee of company, and All right, that right there, agent. That stands out to me. If I was a lawyer reviewing this for an employee and they came to me to review it, and they were in a high level position, that wouldn't bother me. However, if I am acting on behalf of, my client and they're just like a mailroom clerk and they have to sign this agreement, that agent right there, that would make me concerned, because an agent means that you're acting on behalf of the company, facing a third party. So if the employee is not customer facing at any point, then that right there would be a little bit overkill. So I'm highlighting it just to say that may not be appropriate, may or may not. So that's the first thing. And actually, you know what? I think I'll probably go through and write the comments after I'm done. I don't want to take up too much time going through this by typing, and I'm horrible at typing when I feel like people are watching. I make all kinds of mistakes, so I'm not going to do that. All right. Whereas the parties desire that the employee enter into certain agreements and covenants regarding the employee's employment with the company, that's fine. Now, therefore, in consideration of company employing employee at this time, which employment company may terminate at will, employee hereby agrees as follows. Okay, so this is important because in consideration of company employing employee at this time. So that means that if the employee doesn't sign this, then they are not going to get their job. The reason why that right there is important is because there has to be some sort of exchange, and this agreement would not be appropriate to give an employee after they're already employed, meaning it has to be a condition to employment. So if my client was already employed and their boss was trying to make them sign this after the fact, I would say, no, this right here would have to go, and you'd have to change it and get some other type of consideration. So employment company may terminate at will. So what that's saying is that this is not a contract for employment, so you can still get fired pretty much whenever you want to, or whenever they want to fire you or lay you off, however they want to do that. So that right there is important. Okay, this is just a pet peeve of mine. Okay, there we go. No disclosure of customers or suppliers. Employee will not at any time, either during employment or after employment terminates, in any fashion, form, or manner, either directly or indirectly, divulge, disclose, or communicate to any person, firm, or corporation in any manner whatsoever the names or addresses or any other information regarding any of the customers, suppliers, advertisers, or vendors of the company. The employee agrees said information is proprietary to the company and is owned solely by the company, and that the disclosure thereof would be harmful and damaging to the company's business. Okay, that doesn't give me any concerns. Oh, by the way, I have a hard copy here too. Sometimes it's easier for me to read and I can go back and forth. It's weird, but that's just what I do. So, okay. So that right there is fine. It says proprietary to company, which is good. Actually, hold on, let's see. I had another note. Yeah. Harmful and damaging. That's important because sometimes when you're trying to go after claims for someone who breaches a confidentiality agreement, it's hard to prove damages. So it's not like super important, but it is there for a reason, harmful and damaging. So because you're already establishing that somebody breaching it is damaging, it makes it maybe a little bit easier if you ever have to take it to court. But anyway, all right, so 2, let me change that, that's annoying. Not to solicit customers, suppliers, or advertisers. Employee will not either during employment or during the period of 2 years. Okay, whoa, 2 years. That gives me heartburn. Okay, let me finish the sentence. Employee will not either during employment or during the period of 2 years after termination of employment, directly or indirectly, either for himself or for any other person, firm, or corporation, take any action or perform any services. Ew, I don't like that either. Which are similar to the actions taken or services performed by employee for company during said time, which actions or services are designed to or in fact call upon compete for, solicit, divert, or take away, or attempt to divert or take away any of the customers, suppliers, endorsers, or advertisers of the company whom employee knew to be customers, suppliers, endorsers, or advertisers of the company within employee's designated territory. Okay, so basically it's just saying that for 2 years you can't do anything that you've done with this company. You can't do it for another company for the purpose of taking or removing any of the customers. That's cool. That's fine. I don't have a problem with that. So any services which are similar, okay, I can see that. I'll unhighlight that after I read the whole thing. But the 2 years I have a problem with, only because the longer the period of time you have for a contract, the weaker it makes the contract. And this varies by state. So if you can tailor it for a shorter period of time, the stronger the contract is going to be. Usually I try to tell my clients, if I'm drafting a document like this, maybe a year. I would look it up by state first of all, but a year is probably safe, or 6 months is probably the safest. So that 2 years right there, I would definitely have to look that up. That would cause me to do a double take right there. So, and also within employees' designated territory. So this right here is assuming that the employee is going to be some sort of like salesperson, or like I said, a third-party facing employee. If the employee is not functioning in that capacity, then this needs to be changed. So an employee's designated territory is blank. Yeah, that speaks to that. So you'd have to take a look and see kind of what capacity the employee is serving in. So this right here, that's annoying. Not to carry on similar business. Okay, I have a feeling this is going to get a little hairy. All right, as long as employee is an agent or employee of company, and also for the period of 2 years. Oh, that 2 years. Yeah, I don't like that 2 years. I just feel like that's just too long. After termination of employment, employee will not directly or indirectly own. Okay. Will not directly or indirectly own, managed, be employed by, engage in, carry on, or be connected in any manner with any business in blank, engaged in blank, or any other business similar to the type of business conducted by the company at that time. Yeah, I hate that. I hate this. I hate it. And this is why. Because you don't want to keep people from working. And this right here is just way too broad. It just keeps people from working. So I would say you don't want to keep people from doing their trade. If they performed a certain job with your company, it's ridiculous to think that they're not going to perform a similar job with another company. So will not directly or indirectly own, manage, be employed, engaged in, carry on, connected. And it's for 2 years. No, I would say maybe 6 months. And then, if they're going to be maybe working for a competitor, maybe narrow it down that way. Connected in any other manner with any business, that's just too much. So this whole paragraph would just, this whole thing needs to get highlighted. I would strike that whole thing out. So yeah, I don't like that. All right. 4, no disclosure of information. Okay, 4 seems like it's just a continuation of number 1. So okay, hold on. So I would say 4 would need to be combined with number 1. Let me highlight the title. So I'll go back and make a note to say that it needs to be combined. I don't like it being all over the place. It's just confusing and it's just a little sloppy. Employee will not at any time in any fashion, form, or manner either directly or indirectly divulge, disclose, or communicate to any person, firm, or corporation in any manner whatsoever any information of any kind, nature, or description concerning any matters affecting or relating to the business of the company, including but not limited to any information of any kind. I mean, it's just too much. So if you're in an interview, if your former employees in an interview, so they can't talk about any piece of the business, I think that's just a little bit overkill. Proprietary, yeah, that's fair game, but just any information, that just doesn't feel right. Not limited to the names of any of its customers or prospective customers, gotcha. Any other information concerning the business of the company, its manner of operations, okay, that's fair. Its plans, its vendors, its supplies and suppliers, It's advertising and advertisements, it's marketing and sales techniques, it's manufacturing processes, it's pricing and prices, or any other information of any kind, nature, or description without regard to whether any or all of the foregoing matters would otherwise be deemed confidential, material, or important. Okay, so everything that's listed here seems like it's confidential. So I would change that personally to say any confidential information, and then say confidential information is not limited or includes, and list all this stuff out. But then the part at the bottom where it says whether any or all of the foregoing matters would otherwise be deemed confidential, material, or important, I think that's a little bit much. I would just limit it to confidential, material, and important. Because again, you don't want an overreaching contract. Oh, and by the way, my daughter is here. Hey, sweetie. All right, she's asking me for candy, so I'm going to try to keep her quiet while I do this. So she gets candy. Here you go, bud. I see. All right. So, yeah. So I'm going to highlight this bottom part, and I would say I personally would change that so it's limited to just confidential. And again, if this paragraph is combined with the first paragraph, I think it would make it more clear. It's a little redundant, because we already talked about what confidential information is. That's what I would do. So 5, correct that. That's annoying. Records belong to company. All books, records, files, forms, accounts, papers, and documents relating in any manner to the company's business, vendors, suppliers, or customers, it's the same thing, whether prepared by employee or anyone else, are the exclusive property of the company and shall be returned immediately to the company upon termination of employment or upon the company's request at any time. Okay, again, that's just a continuation of confidential information. I think this is kind of overkill. It's redundant. It's kind of annoying that I have to spend time reading redundancy. So I would highlight that and say it needs to be combined with the paragraph at the top. And I don't have a problem with any really of the verbiage. Yeah, okay. 6. Notification of subsequent employment. I can already tell. I'm not going to like this one. During a period of 2 years immediately following the termination of employee's employment, employee shall notify company in writing by U.S. mail, return receipt requested within 5 days of accepting employment with any other employer, including self-employment. Said notice shall include the name, address, and telephone number of the new employers, the date employment began, and the duties to be performed by employee. Way overreaching. I really don't like that. There goes that 2 years again. Way overkill for the time frame. If it were like 6 months, I really still probably wouldn't like it, but I probably would be able to stomach it. But the fact that it's 2 years and you're obligated to tell them 2 years after you're employed where you're working, I really don't like. I don't like that. I would strike this whole thing. Actually, let me just go ahead and highlight the whole thing. Let's see. Why is it saying my video has ended? Hold on. It's still streaming according to my thing. That's weird. Hold on a second. I'm getting a notification that's saying that my video ended. All right. Looks like it's still going, so I'm going to keep going. I don't know why I'm getting that notification. You guys can probably see it too when I put it up there. That's weird. Alrighty. So I'm going to keep going. All right. Breach. That's annoying. The parties hereby agree that each of the foregoing matters is important, material, and confidential, and gravely affect the effective and successful conduct of the business of the company. Okay, the reason why that is important is because they're saying that every single thing in this in this contract. Every single point is important. So sometimes with contracts, if you breach the contract, but it's a minor issue, sometimes the court will say, okay, well, it's just a minor issue, so the rest of the contract is going to be upheld. It's not going to be considered a breach per se. So what this does is it negates that ever happening and saying that every single point in this contract is highly important. And so if the employee or whoever signing it breaches any piece of it, then the company can come after you. So I guess it's okay. I mean, I can understand them putting that in there. If I was acting on behalf of the employee, I would try to get that taken out. If I'm acting on behalf of the company, I'd say no, it absolutely must stay in. So it just depends on, which side of the argument you're on. Any breach of the terms of this agreement is a material breach of this agreement and from which employee may be enjoined. Okay, that's important, enjoined. So that means when you say enjoined, that means injunctive relief. And so what injunctive relief means is the court, instead of awarding, or maybe not instead of, but in addition to maybe, of awarding monetary damages, they'll actually give a company injunctive relief, and it would prevent the employee from actually taking a job, or it would make the employee have to quit the job. So that's injunctive. It would actually force you to do something. Courts don't usually like injunctive relief. Oops. Sorry. I just did something to my phone. Courts don't usually like injunctive relief. They like to stick to monetary damages. But when you put things like this in your contract, you're more likely to get injunctive relief. So enjoined. That's why that's there. And for which the employee shall also pay to the company all damages. Okay, so there we go. Those monetary damages that I just talked about. So that's in there as well. Sorry, these people keep trying to call me. I'm on a live. Okay. Including not limited to compensatory, incidental, consequential, and lost profit damages. So what that means is that it's going to be extraordinarily expensive if you breach this contract and the company has to come after you. You're going to pay out the nose, which arise from the breach together with interest. See, interest, I don't like that. Because there's no interest rate specified. So I would get that taken out. Costs and companies' reasonable attorney's fees through appeal. Oh gosh, yeah, this is going to be painful if they come after you to enforce this agreement. So that's going to be bad. Hold on. Oh, well, let me see. Hold on. I think my live is interrupted. I can't tell if it's still going. All right, but I'll keep going. Nope, still going. All right, no waiver. Company may waive a provision of this agreement only in a writing signed by the duly appointed representative of the company. Okay, so nobody can change this agreement unless they're an appointed representative of the company. So you need to know at least who that representative is, or at least what position is considered a representative. It doesn't have to be an actual person, but it can be just like a job title. That needs to be cleared up. The waiver by the company of a breach of employee of any provision of this agreement shall not operate or be construed as a waiver of any subsequent breach by the employee. Okay, so it's just saying that if we let you slide once, that doesn't mean that you are automatically entitled to a pass again. So that's fine. Not a contract for employment. Yep, we already established that at the beginning, but it's good to make it clear. That makes perfect sense. The agreement is not an employment contract and does not give employee any employment rights. Yep, got that. 10, miscellaneous. That's annoying. No change, addition, deletion, or amendment of this agreement shall be valid or binding upon either party unless in writing and signed by the party. There are no oral or other agreements or understanding between the parties affecting this agreement. The agreement replaces and supersedes all prior agreements and understandings as to the subject matter. Okay, yeah, that's pretty standard, saying that basically all of your agreements have been reduced in writing to this right here. So anything oral where they tell you, oh, don't worry about it, it's fine. If it's contrary to anything that's written in this contract, then you definitely should not take that as gospel. It needs to make its way in this contract because of that clause right there. So a company employee, yeah. So one of the things that I noticed that was missing in here is a clause that speaks to the jurisdiction. So basically, whenever you, if I was acting on behalf of the company, I'd make sure this is in there. So you don't want to have to bring a suit in a court that's inconvenient. So you'd want to put down a jurisdiction that is located near you, that's located preferably like in your county. So I'd want some sort of clause in there that speaks to that. And I think that's it. Hold on, let me see. I made one other note. I have a list of notes that I like to go through each of the contracts that I keep by me when I go through it. Severability. Usually there's a severability clause, which means that if any portion of the contract is deemed invalid or unenforceable, then the entire contract isn't going to be null and void. So that piece that's invalid is just removed, and then the rest of the contract stands. So that's a severability clause. This doesn't have that in there, and I would definitely include something in there that says that. So that would, if I was acting on behalf of the employee, I probably wouldn't necessarily force that in there because really it's the employee who's bound. But if I'm acting on behalf of the company, I would absolutely, definitely include that in there. So, all right, I hope this helps. I'm going to go through and, like I said, I'm going to type up some of the notes as I was kind of thinking, and I highlighted a lot of it, but I'll go through and put them in the comments, and I'll upload this document so that way you guys can see it in just a minute. All right, thank you, and I'll see you guys very soon. Let me know if this was helpful. Give me a like, put a comment, and I would appreciate it. All right, thanks.